The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save this United States and this honorable court.
Thank you. Be seated. Certainly a pleasure to be in Judge Blatt's courtroom, and we're happy to hear arguments in the first case, counsel.
Your Honor, I wasn't sure if we should
Please.
take.
Thank you.
May it please the court. My name is Troy Shelton, and I represent Tim Capps, the appellant in this appeal. This case is about requiring contracting parties to honor notice and cure rights. Here, Capps negotiated a contract that protected him in case of an early termination. Newmark was always free to terminate the contract whenever it wanted and for whatever reason without cause. But if it did so, then there would be serious financial concessions that Newmark would have to make to Capps. Newmark could avoid that pain and expense, however, if it terminated Capps for cause, and that is what it did. Yet the contract here limited for cause terminations. It required a material breach of contract and written notice and an opportunity to cure. Here, Capps was denied notice and a chance to cure.
Well, New York law doesn't require strict compliance, does it?
I'm sorry, Your Honor.
New York law does not require strict compliance on the curability and so forth.
My understanding, Your Honor, is that it does require strict compliance with the notice and cure provision. There is an exception for breaches that are incurable, but the written notice, for example, an oral notice would never be sufficient if the contract requires written notice. That's my understanding of New York law, Your Honor.
Well, didn't the judge find it was incurable?
Yes, Your Honor. The judge did find that it was incurable. It's unclear what the district court understood incurability to mean in this case. Under New York law,
Does it count? I mean, your client tried to steal from his employer. It seems like to me that that's a hard one to cure. I mean, even if you give the money back, you still tried to steal from your employer, right? Based on the findings, I understand you claim he didn't try to steal, but they found that he tried to steal from his employer. How is he supposed to cure that? I mean, once you've tried to steal, it's not like giving it back actually cures the problem, right?
I understand that issue, Your Honor. I think that issue goes more to the issue of materiality, and we don't contest the materiality of the so-called equity clause scheme, but we do contest whether that was curable or not.
Well, but how? Well, that's what I'm trying to understand, right? I mean, the problem here is whether he was successful in stealing or not might be curable. He might be able to return the money he stole. If I took your wallet, I can give it back to you, but I still tried to steal it. And if I tried to steal it, I can't undo my attempt, right?
Yes, Your Honor, but the case law doesn't require sort of restoring the status quo ante. That is not what curability requires. Instead, to cure a breach of contract means to stop the offending conduct and to begin to substantially perform. And so a breach of contract—
Do you have any example where somebody found that you can cure the breach of contract where the breach is, I tried to steal from you? That seems peculiar.
Well, you know, when you look at this particular contract, Your Honor, there were 3 provisions that allowed termination for cause. There's sections 3A, 3B, and 3C. 3C allows termination for cause if Capps, for example, had committed a felony and been convicted. Section 3A—
a felony like attempting to defraud his employer.
Not an attempt, but an actual conviction. Any kind of felony, Your Honor. Section 3A allowed termination for cause if CAPS had attempted to defraud or embezzle from Newmark or its clients. Now, Newmark has never relied on that provision. Their termination letter didn't rely on it. They didn't argue that provision to the district court.
Well, let me ask you this, counsel, how is CAP's failure to prove termination without cause not functionally equivalent to Newmark proving termination with cause?
Your Honor, so under New York law, there's a sort of a special rule that applies when a party is claiming improper termination. Under New York law, all the terminated party has to come in and do is say, I had a written contract, it was terminated before it ended, and it was terminated without notice and a chance to cure. And after they prove that, the burden then shifts to the terminating party to prove cause for termination because it's an affirmative defense.
But aren't you overreading that order? I'll give you that there's a little confusion in the first part of the order about allocation. But later in the order, the judge specifically finds that Newmark proved for a cause. Is that right?
It's correct that she finds that there was cause, but the problem is that because of the misallocation of the burden of proof, essentially when a court, any kind of fact finder is looking at the facts, they essentially put on lenses about how they view the facts. In a case that was as close as this, we don't know if the burden had been correctly allocated, how the district court would have come out.
Well, this is a bench trial. And
Yes,
the trial judge is going to get a lot of discretion from us as to what the facts are. Don't you understand that to be the law?
Absolutely, Your Honor. I understand that.
Well, as a district court judge myself, switching gears here to another issue, the first concern I've got here is subject matter jurisdiction, and the information before us doesn't allow us to confirm the existence of diversity jurisdiction. Can you give us some more information to establish the citizenship of the parties before we get into too many other issues?
That's fine, Your Honor. At the beginning, there were numerous other parties that were involved. Some of them were dismissed. Frankly, I believe Newmark might be an LLC, or maybe they were at the time of this case, and I understand that would be based on where its members lived. And unfortunately, I don't know that information. It wasn't contested below. So
you didn't allege it, right? I mean, you alleged that their principal place of business was in Georgia, which would be helpful if they were a corporation, but it doesn't matter if they're an LLC, right?
that's right. You need to look at the location of the members, and unfortunately, I don't have that information.
And we don't know where the citizenship of Newmark Southern Region LLC is?
I do not, Your Honor, because again, it wouldn't be based on the principal place of business. It'd be based on the location of the members. My assumption is that one of the two is a wholly owned subsidiary of the other, but that's merely an assumption on my part.
Well, who are the members of Newmark? Don't know that.
Again, Your Honor, I'm sorry. I have to defer to Newmark's counsel for that information.
Can I switch subjects for you a little bit and ask a different question?
Yes, sir.
So there's a significant discussion, which I understand, about whether North Carolina would recognize aiding and abetting a breach of fiduciary duty. Hypothetically, except for me that we find that they would not, for my hypothetical. Why would we think they would then recognize a civil conspiracy to breach a fiduciary duty? Why wouldn't the analysis for those two questions be the same? So in other words, whether you're aiding and abetting a breach of fiduciary duty or whether you're conspiring to accomplish a breach of fiduciary duty, the analysis looks quite the same. And so why would we not think that North Carolina, whichever way they think about those questions, they think about them the same way?
I agree with you that they would likely think about them the same way. I think that they're likely to, I believe that civil conspiracy has been used when the object of the conspiracy was the breaching of a fiduciary duty.
So so can you point me to a case that did that? So we found a few, we didn't find any in the briefing. We found a few that rejected civil conspiracy based on breach of fiduciary duty, but none that have held that such a claim was valid. Do you have a case where a court in North Carolina actually did that?
I'm sorry, I'm not at the tip of my fingers, Your Honor. I'm happy to submit supplemental briefing on that. But I would note that often fiduciary duties arise from a contractual relationship. And so when that happens, the tortious interference with contract and the aiding and abetting the breach of fiduciary duty become very tight. And it was essentially the same facts that were being alleged in this case. So it strikes me as unusual that North Carolina would recognize intentional interference with contractual relationship on the one hand, but if that contractual relationship was a fiduciary duty, then the court would essentially immunize that kind of misbehavior. North Carolina, as many other states, are highly protective of fiduciary duties. So it strikes me as unusual that a court would say, well, if you know that someone owes a fiduciary duty and you help the fiduciary breach that duty, it's no problem.
But you agree that if they don't recognize the aiding and abetting a breach of fiduciary duty, they would also not recognize a civil conspiracy to violate a fiduciary duty?
I think that there's simply a different question. So I'm not sure that I can quite agree that because we'd fell in one, that we'd fell in the other. There are some different policy considerations for each one. They have different elements. I take your point though, that those three claims I believe that they're animated by similar policy concerns, but I believe those policy concerns favor us as opposed to New York.
If we determined that North Carolina did recognize the civil conspiracy to breach of fiduciary duty as you've alleged, can you help me understand how you've plausibly alleged an agreement? And I understand that that's not the rationale that the district court gave below, but when we look at the complaint and sort of in light of Twombly and the standards that we have for recognizing a plausible agreement, can you help me understand how you did that here?
I think it's pretty much undisputed that there was some coordination going on between Katz, Harris, and Newmark. So to step back and look at the timeline, there was a dissolution by Greg Katz, the co-partner in the CTG partnership. And at that point in time, Newmark steps in. In part, they're talking to Mr. Katz, they're talking to Harris as part of what begins as an HR investigation, but they're also involved in the winding up of the affairs. So without a doubt, there's communication.
Well, but that's the whole idea that like parallel conduct is like not enough. Yes, they're all involved because they have relationships, but to suggest that there's an agreement between Katz and Newmark for Katz to violate his fiduciary duty, we got to show that agreement, right? And to show that they were both acting independently in ways that might be or might not be consistent isn't enough under Twombly. You got to have more than that.
I understand. That's correct, Your Honor. Though parallel conduct normally involves no communications between the parties at all, right? But in this case, we know that there was significant communication going on between Newmark and Harris. They were talking both as part of this HR investigation, but they're also talking with Harris and having separate conversations with Harris. There's Lou Alvarado, for example.
Okay, so I understand they were working and you claim that they were talking to each other. Is there any, I just want to understand what the universe is. What do I need to consider? What other allegations in the complaint do I need to consider in doing the Twombly analysis on the agreement here?
Whether they had a similar motive to act together, to cooperate. They were going, essentially the allegation is that they wanted to continue working together without Caps. They could both profit if Caps was cut out of the picture. So
but on the complaint, you allege, I mean, I'm just looking at the complaint, right? And I understand during the trial, it came out that maybe your client was not exactly as alleged in the complaint, but in the complaint, it says these are like super productive, making a lot of money. Why would Newmark have any incentive to cut him out, right? If he's as productive and helpful as you allege that he was, and he wasn't stealing money from them, why would they have any incentive to get rid of him? I don't see their motive to conspire with Katz at all.
Well, I think that they preferred to continue working with Katz at the end of the day and not with Caps. And the rest of the CTG team essentially wanted to remain.
Why would that be? I mean, if you got two productive members, like maybe they can't work together anymore, but in fact, like Newmark went to your client before they found out he was stealing from them and said, we want to give you a new contract, not as part of this agreement with your former partner, but we just want you to keep working with us in a different capacity. And they offered him a new job at a raise. Right? So what's their motive? That's what I'm having trouble with. If they're doing that, what is their motive to undermine him in any way, shape, form, or fashion?
Well, I think that would be separate from the question of whether there was a civil conspiracy.
Well, but the motive matters, right? We've said before that we look at motive and we're not going to presume an agreement in the lack of any real evidence of an agreement where there's no motive to enter that agreement. And I don't see Newmark's motive to enter the agreement.
Well, I think it seemed
Alleged agreement, I should
Yes.
say, obviously.
There were also pending deals that were going on, and they were having to determine how the commissions were going to be distributed during the wind-up phase.
Are these the ones that your client was stealing the commissions on, or are there others?
No, Your Honor. These were other deals that had already closed or were in the process of closing. There were many other deals that were going on.
Right, and they want him to keep working on them, right? That's why they offered him a new job, right? They offered him an extension and a new job because they wanted him to keep working there. So I'm still having trouble understanding their motive to enter this agreement to breach the fiduciary duties of the partnership.
I think the motive first starts with Katz's motive. Katz wanted those commissions.
I understand Katz's motive.
Well, I think Newmark's motive is derivative. So Katz's motive was he wanted those commissions were going to have to be split through the CTG partnership. He wanted most of those commissions to flow to him. Newmark decided that it was preferred to keep Katz happy as opposed to Katz. And so they were trying to funnel those commissions to Katz as opposed to Katz. And that is how that's the motive of the civil conspiracy.
Is there anything else that you would want me to look at to think about the plausibility of having alleged a conspiratorial agreement here?
I don't think so, Your Honor.
Thank you.
I wanted to turn back to one issue of curability that Your Honor had raised. Under our definition, again, curability is asked whether it's possible to stop the offending conduct and whether it's possible to substantially perform going forward. Your Honor, what I wanted to note is that most of the time under this contract, most breaches, I believe, are going to be curable, but there are a handful that are not curable. And I think that it's helpful to look at those as a contrast and juxtaposition. First, a status-based breach is usually not going to be curable. That's a felony conviction.
So like that being, well, the one status would be is like a thief.
Usually it's adjudicated misfeasance, which is what the Second Circuit used when it was applying New York law in the Jeffrey Hyundai case. They said the difference was that this was adjudicated misfeasance. It wasn't simple misfeasance. So that's why it was a status change that was incurable. Another issue would be an inability to cure within the cure period. For example, this contract provided 30 days of cure. If it wasn't possible for CAPS to resume performance, in a construction case, for example, someone runs out of money, they can't continue performing within 30 days. Then they wouldn't be able. Then that would be an incurable breach, just on those facts. And finally, that as I was saying earlier, if the contract simply doesn't provide cure rights, which is what this contract did, it said if you committed fraud or embezzlement.
Thank you, counsel. We've
Thank
got
you.
some time on rebuttal for you, I think.
Thank you, Your Honor.
Thank you, counsel. If you don't mind starting with Judge Hendrick's question about the LLC and its members and their citizenship.
Absolutely not. The LLC that is the appellee, which is Newmark Southern Region, is not a citizen of North Carolina. Its members are corporate entities venued in Delaware and New York. And so there has never been an issue about diversity of citizenship among the parties.
Would you be so kind as to help us assure of that by submitting a letter of the members of the LLC and information about their citizenship?
Absolutely.
Thank you, counsel.
Counsel David Paul, by the way, Assistant General Counsel for Newmark, appearing for the appellee. May it please the court, and good afternoon. Thank you. Counsel started and ended with curability, so I'd like to tackle that issue first. Judge Richardson, you asked some very poignant questions which go right to the heart of the legal deficiencies in the appellant's position. This issue is not curable. The facts of this case demonstrate that Mr. Caps's conduct was absolutely not curable. As a matter of New York law and under the clearly erroneous standard that applies to the district court's factual determinations, this court should affirm unless you are convinced and with conviction that the trial court erred in her 47 pages of factual findings, which detail the attempted misappropriation of corporate assets that went to the heart of the party's contract. If you think about it, Capps' argument on this curability question is pretty absurd. His argument is that a company who discovers that its broker is engineering a scheme to defraud it of the gross profits of the contract, the fundamental benefit of the bargain, who then stops once and then lies about it, and then stops the scheme only because he's caught, that somehow provides him with the right to continue under the contract and takes away Newmark's right to fire them for cause. That's absurd. There's not a case in this record or in the land that supports that rationale.
So his argument I take is, based on the language of cure, it says, well, as long as I stop doing it, and there are some New York cases that seem to say, stop, that's sufficient. So help me think about the legal side of this. Like why,
Sure.
What do I look at in
Sure.
New York law to understand that the absurdity that seems sort of somewhat obvious, but is maybe less obvious when you read the case law?
So there are two things you need to look at, Your Honor. First is the standard of review is clearly erroneous because these are factual issues. So number one, you're deferring to the fact finder. So appellate has to reach a very high bar of demonstrating that there was error. He has not. Number two, the question is, could this be cured? Could he stop? The case law out of New York demonstrates that a material breach that contains this kind of dishonest and patently offensive conduct that goes to the heart of the party's contractual relationship is material and incurable, and it provides the counterparty under the contract with an absolute right to terminate without any cure. That's Forlick and Muir.
Give me, what are the two cases? Like you just gave me two cases, but I was talking, so I didn't hear them. What are the two that you think are closest to telling us this idea that, if you attempt to steal from somebody, stopping stealing hasn't actually cured it?
Forlick and Muir are directly on point. Both of those cases involved 7-Eleven franchises. I'm not sure what was happening with 7-Eleven franchises in the 1990s in New York, but there are two similar cases where the franchisor was deprived of its profits under the contract because the franchisee was underreporting its sales by artificially inflating costs. So there were deductions and they were pocketing the rest. That's very analogous. And the court found in both of those cases that those breaches constituted dishonest, patently improper conduct that went to the heart of the matter, that avoided the contract counterparty from obtaining the benefits, the fundamental benefits of the bargain under the contract, and they were material and incurable breaches. The other thing that you should consider, that's the case law, yes, for legal concepts. Another factual issue Your Honor should consider is that it is not disputed that Tim Capps' contract does not provide an absolute cure right. The contract provides a cure right only to the extent the breaches are curable. These breaches are not curable as a matter of law. Newmark was not required to provide an opportunity to cure because they are not incurable. And the facts that were presented at the week-long trial before Judge Flanagan firmly support that. And so you have, those are the reasons why there's the curability analysis confirms that this court should affirm. Judge Floyd asked a question about burden shifting, and he stated it the right way, and that is that under New York law, it is black letter law that a plaintiff, such as appellant here, who is asserting a breach of contract claim, bears the burden of demonstrating substantial performance. That is a separate question from, does the defendant have to demonstrate cause? And I believe Judge Hendricks made a similar point about, aren't they two sides of the same coin, which is exactly the factual conclusion and legal conclusion that Judge Flanagan drew. But in reality, they are actually two separate things. And so when in the papers, appellant argues that the district court somehow improperly shifted the burden of proof onto the plaintiff, that's simply not true. There's nowhere in the opinion does Judge Flanagan state that Mr. Capps bore the burden of demonstrating lack of cause. What the judge did say is that he bore the burden of demonstrating substantial performance, that he failed to do so, and that his failure to perform his obligations under the contract constituted material breaches of the contract and constituted cause, to your point, Judge Hendricks. They are two sides of the same coin. That is not always the same. That is not always the case, that the facts answer both questions, but they certainly do in this case. An example of where they wouldn't, facts wouldn't entirely overlap is where there is a breach that, sorry, not a breach. There is substantial performance of a contract, but then the reason for cause was something unrelated to that. Counsel mentioned a felony conviction. Mr. Capps' contract provided that one of the multiple bases of cause was if he were to receive a felony conviction, that would constitute cause. So in that scenario, Mr. Capps could come into court if he contested that termination for cause. He could demonstrate that he complied with his company, with all of his obligations and company policies. And then he could contest that the felony conviction was valid, or whatever he would contest, that the cause itself was improper. In that scenario, Newmark would bear the burden of demonstrating the propriety of the cause based on the felony conviction. It's simply not the case here, because the two are absolutely inextricably intertwined. And that's why, if there is any concern about burden shifting, I think Your Honor mentioned that it was unclear and that the judge wasn't explicit about the burden, at least in the initial part of the opinion. If there is any concern, it's of no moment. There is no error, because the factual findings rendered by Judge Flanagan are entirely outcome determinative. She rendered rulings.
Can you shift to the civil conspiracy question? And I had two questions for your colleague, and I wanted to give you a chance to address them. One is, do we see, or do you have sort of case law addressing civil conspiracy to violate a fiduciary duty as being recognized under North Carolina law? And then secondarily, assuming that there is such a cause of action, do you think that the complaint plausibly alleges, and I mean, I know you think it doesn't, but why do you think that the complaint does not plausibly allege an agreement under Twombly and that line of cases?
Absolutely.
If you don't mind, let me add to that question, because they're all coming together. As to, can tortious activity against Capps serve as a basis for Capps' civil conspiracy claim against Newmark?
That is related. Thank you. I'll handle all of that at once. To your first question, is there a case that out of North Carolina that upholds a civil conspiracy claim where the underlying bad act is an aiding and abetting a breach of fiduciary duty? Answer is no. The reason for that answer is that North Carolina does not recognize a cause of action for aiding and abetting breach of fiduciary duty. No, but it doesn't have to be a conspiracy to aid and abet. It can be a conspiracy to breach the fiduciary duty, right? You take out the aiding and abetting piece, right? And so it's a conspiracy. Instead of aiding and abetting, it's conspiracy. Correct. Right? And so they are two different questions, right? I understand.
And there's plenty of case law, and you can assume for the argument that they don't recognize aiding and abetting breach of fiduciary duty. But what I don't see is the same discussion or thoughtful engagement on the question of, is there a conspiracy to breach the fiduciary duty?
Only if there is an allegation in the complaint, which is obviously not here, but only if there's an allegation stated in the complaint that the co-conspirator, the company, made some unlawful act in furtherance of the conspiracy to breach the fiduciary duty. The starting point is that Newmark does not have any fiduciary duty to Mr. Capps. There's no allegation of any. That's easy. There is an allegation that Katz and Capps owed fiduciary duties. That was a question in the case. It's been dismissed and settled.
Well, in regards to the civil conspiracy, another question I've got is, the court effectively held that a tort claim against Newmark must underpin the conspiracy claim, but doesn't the law simply require that a wrongful act by an alleged co-conspirator would qualify?
It could. The first stopping point is the court's conclusion, which is correct, that a civil conspiracy claim cannot be maintained absent a valid tort claim against that joint tortfeasor, the company in this instance. On the line of cases that there's a narrow line of cases, Your Honor is correct, where the acts of the joint tortfeasor could serve as the basis for the claim. But here, those allegations involve Mr. Katz and Mr. Harris, and they're moot. because Mr. Capps settled with Mr. Katz and Mr. Harris, and he dismissed all those claims. So there are no claims of any
They can still be a
nature.
joint tortfeasor and not be in the case, right? You don't have to sue everybody that's a joint tortfeasor, and they typically do, but you don't have to, right?
That's true only if the plaintiff alleges unlawful acts by the defendant. And we don't have that. And the question was, can Capps rely on the alleged bad acts of Katz and Harris, not of Newmark?
But when the
Because there are
district
none
court-
alleged against them.
When the district court dismissed Cap's civil conspiracy claim, Cap's claims against Katz were still pending, weren't they?
Yes, and then a year later, the individuals all settled. And so what I'm saying is it's moot because those claims are gone. They've been settled and dismissed. And so, and if you think about it, a conspiracy claim is really assigning liability for the bad act. It's making sure that the victims are not limited, right? Whether it's civil or whatever, limited in their recovery, in the sense of only alleging bad acts by one when multiple people are involved. And if the basis of Mr. Capps's claim for the tort was really derived from his claims against Katz and Harris, he has already resolved that and potentially recovered on that.
Yeah,
in
but he
the
only
settlement.
resolved the claim against one party, right? So his theory is, listen, you two guys agreed to deprive me of my rights, fiduciary rights. One of you is reasonable, and so you settle. The other of you is unreasonable, and so you don't settle. But that doesn't make the claim go away against the unreasonable one, right? That claim still remains.
It
Doesn't
does.
make it moot, right? Because he was a defendant at the time, and decided to settle. It wasn't dismissed. If it was dismissed, that's a different story, right? But if it's dismissed because it's settled, then that's not an admission of liability, but it's not a indication that there's no claim either.
It's an admission that there's no current claim against the prior defendant that he settled with, because that has been dismissed. But to your point, what you're saying, I think, Your Honor, is at the pleading stage, they were still viable. And I understand that. But that claim can only continue against Newmark if the plaintiff alleges sufficient allegations of wrong acts by Newmark, and he has not. This goes to the second part of your question that you posed for me a few moments ago that you were asking counsel about. There are no wrongful acts on the part of Newmark, which is why, one of the reasons why Judge Floyd, why the judge properly dismissed the tortious interference claim, which had that claim been proper and allowed, then that tort against Newmark could serve as a basis for a conspiracy claim, because then you have a valid tort claim against the joint conspirator. But in this case, the Judge Flanagan found that there was not a properly stated one, and she dismissed it properly as a matter of law for the simple fact that the allegations stated in the complaint showed that Newmark's alleged conduct, even at the pleading stage, could not have been the but-for cause of Katz's termination of his contract with Capps, because under the timeline alleged in the complaint, Katz dissolved the partnership with Capps before Newmark was alleged to have ever been involved in working with Katz and Harris to Kapps's detriment. And so based on
With
that
that holding, so imagine for a minute if we found the district court erred in dismissing the civil conspiracy claim at the motion to dismiss stage. Would the court's finding, could we rely on the court's finding on the tortious interference to find that error to be harmless, given the sort of close nature here, or are they really sufficiently separate because one's really about an agreement and the other is about actual interference? You understand what I'm trying to get at?
I think I do, Your Honor, and I think that you can rely on that as being harmless.
Help me understand how I'm not sure that works. Help me understand how we would do that, because they're fundamentally different elements, right? And so the court didn't address the agreement aspect of the conspiracy charge.
Right. The allegation on the conspiracy claim would be that Newmark tortiously interfered with the contract by colluding with Katz and Harris to induce Katz to cancel the partnership, the alleged partnership. But if your hypothetical, Your Honor, which is not entirely hypothetical, but the tort claim was actually dismissed at the pleading stage, that tort is now gone and cannot serve as the basis for a civil conspiracy claim. So then if you found that the
conspiracy claim is based on the breach of fiduciary duty, which could have happened before the dissolution of the partnership, but it could also happen during the windup of the partnership, right? You still have fiduciary duties during the windup, right? And I get we're a couple levels down because we're assuming a few things, but on the narrow question of, do you have fiduciary duties during the windup? The answer to that is yes. So while the inducement claim doesn't work because of the timing of Newmark's actions, perhaps the fiduciary duty claim, if it can serve as the basis of a conspiracy, would suffice.
It could, had plaintiff actually alleged that Newmark engaged with Katz and Harris during the windup. Appellant argues that in his papers, but the complaint actually does not say that. The complaint actually says that the tortious conduct between the company and the other individuals occurred pre-windup. It occurred at the point in time of allegedly inducing, but based on the fact pattern it couldn't, allegedly inducing breach or dissolution of the partnership, not the windup phase. The complaint says nothing about the windup phase. And so what counsel's trying to do is he's following your logic and looking to amend his pleadings on appeal. And that's obviously way too late in the game for that.
So it's your contention is a timing question as to when Newmark entered the dispute.
It's timing in the sense that the timing of the factual allegations by the plaintiff matters quite a bit. And that's part of what Judge Flanagan found when she dismissed the tort claim, because in order for the tortious interference claim to continue, Newmark's alleged conduct has to be plausibly the but-for causation of termination of the contract, and it just could not have been based on the timeline. And that was her rationale, which was sound and should be affirmed along with the other rulings. I think I've answered most of your other questions. Judge Floyd, you made a comment that I'll close with, and that is that this is a bench trial in front of an experienced district court judge. She was the sole fact finder. Her ruling is subject to deference from this court unless you have a strong conviction that she absolutely got this wrong. All of these issues, but for the 12B6 determinations, all of the other issues on materiality and curability, these are fact-intensive issues. These are issues, this is classic defer to the district court stuff where you defer to the judge who can look the witnesses in the eye and assess the credibility and weigh their testimony against the documentary evidence, which may or may not conflict with their testimony. And you see evidence of Judge Flanagan undertaking a very conscientious process in making those credibility determinations when you read her 52-page opinion, because she actually takes the time to connect the dots in a very reasonable way between the witness's testimony, the documents that were submitted, the motivations of the parties at the time, noting that Mr. Capps had become anti-company and was sort of motivated to go pursue this equity scheme for his own benefit and deprive the company. Those are all things that are woven into a very well-reasoned and thoughtful opinion that should be affirmed for all the reasons. Thank you.
Thank you, counsel.
I'd like to resume the discussion of curability. It's not our position that Newmark was forced to work with Capps. If they didn't want to work with Capps, they were always free to terminate Capps without cause. Our point is simply that this conduct was curable. It was curable as to Hopper and Center.
Tell us about the 7-Eleven cases, right? So except for a minute, and I understand you don't like it, but except for a minute that he tried to steal from his employer, like in the 7-Eleven context. Why don't those two cases suggest to us that like trying to or actually stealing from your employer or franchisor in that particular scenario, that's uncurable?
So there's several problems with those two cases, which are both Southland versus Meir and Southland versus Froelich. First, those cases are actually not about termination, they're about rescission. So there's a special rule that some courts have applied. They say, well, we're not even going to look at curability rights if you're seeking rescission. If something's so bad, then we'll just set aside curability rights, and you rip up the contract and set it back the parties back to where they were before the contract was entered into. Those are the Southland cases. I would refer the court to the case of Manpower versus Mason, which does a really good job explaining the difference between curability rights for rescission and curability rights for termination. And it doesn't discuss those two cases exactly, but it's talking about the same points of law and those same cases that those cases were relying on. There are no New York cases that have ever cited either of those Southland cases. So it's not even very clear to me that those cases represent New York law. And I'd also commend
So what's the best, I'll give you the same right? So what are the cases you want me to look at to suggest that an attempt to steal can be cured by stopping stealing?
So the first is the Manpower case. I'll set that aside. The second case, the next closest case is a case called Senko, where it's not exactly about deceptive conduct, but it is about some safety problems with some equipment that was supposed to be provided. And the provider of the safety equipment terminated them. They said, we've lost faith in them. We can't trust this kind of equipment. So it's the same element of trust. And they said, we can't trust them. And the court said, no, there are no sort of lost confidence, lost faith cases under New York law. That is not a ground for ignoring cure rights. You still had to give them written notice and a chance to cure, even if you've lost faith in them, because that's the deal that you struck. And that's our point, that this is the deal that the parties struck. They didn't have to give any cure rights at all under this contract. I see that my time is up. Your Honor, unless there are any other questions, I'd ask that you reverse the judgment and reinstate the claims dismissed at the Rule 12 stage.
Thank you, counsel. As some of you know, we normally come down and greet counsel, at least as of yet. We have not resumed that tradition in the Fourth Circuit. We certainly hope we do so soon, but we appreciate you being here and we certainly appreciate your argument. The court will take a brief recess.
Thank you.
judges of the United States Court of Appeals for the Fourth Circuit.
Have you seated? I'm happy to hear argument in KI versus Durham Public Schools. Counsel?
Good afternoon, Your Honors, and may it please the court. My name is Stacy Gahagan, and I am here on behalf of appellants KI, a child with autism, and her mother JI. And we're asking this court to do three things. First, to review the district court's dismissal of appellant's claims due to lack of subject matter jurisdiction. Second, to find the appellants satisfied the exhaustion requirement or that equitable tolling applies to their claims. And third, to remand this case to the district court with instructions to consider the case on its merits. The IDA's exhaustion
Counsel, if
provision.
you could, you said you're asking us to apply equitable tolling. Did you brief that issue?
We did, Your Honor, about the affirmative defense and equitable remedies that were available.
Yeah, I recall the discussion of functional equivalent. Maybe you did the other as well.
We did, Your Honor, in regards to the question of when it's a claims processing rule that affirmative defense, that it operates as an affirmative defense. Your Honor, the IDA.
You agree this is a claims processing rule, right?
I'm sorry, Your Honor.
You agree this is a claims processing rule that we're dealing with?
Yes, Your Honor.
Can you stay? I know we're gonna get you off order where you wanted to be, but Judge Quattlebaum asked about what I think is your second step. And so just assume for a minute that it's not jurisdictional. The trouble I'm having is figuring out how any feasible equitable remedy exists. Can you help me understand what you believe the best equitable doctrine is, whatever it might be under whatever name, and why it would apply here?
Yes, absolutely. So I would direct your honors to the recent case decided by the Supreme Court earlier this year, the Boekler v. IRS, and because the facts are very similar to our case. The plaintiff in the Boekler case filed his appeal one day late, and the Supreme Court addressed that directly and said that it was an ordinary, non-jurisdictional deadline subject to equitable tolling, and remanded to the Court of Appeals to determine if the equitable tolling applied.
So was that, help me a little bit more with that. Was that was the appeal of that from a district court to the Court of Appeals, or what court to what court?
It was to file an appeal with the tax court. A lower level had made the decision, they were appealing to the tax court, and they were one day late in filing the appeal. And the Supreme Court rejected that the one day was going to make a difference, and that the court should go back and look.
Right, but what it says there is, yep, not jurisdictional. But then they don't say that equitable tolling or an equitable doctrine would apply. They just say we're going to let that be decided below. We sort of have, you might say, that question now come back. All right, so if we agree with you that it's non-jurisdictional, we still have to understand what equitable exception or tolling or rule allows us to excuse the late filing, right? I mean, that's what I'm trying to get at. I understand what that does is get you to my question, but my question is, what is the equitable tolling doctrine that applies here, right? I mean, are you following?
I think I am. Okay. So, Your Honor, I mean, and we would be perfectly satisfied with a remand to the district court to determine if equitable tolling applies.
Yeah, but there has to be one that's plausible, right? We don't send it back to the district court to do something that it can't do, right? And so what I want to know is, what is a plausible even equitable doctrine that I could understand?
Right. So, I mean, we would argue that estoppel would apply, and we would also argue that it is that the district court, in looking at all the steps that the appellants took, specifically said in Joint Appendix page 243 in Note 8, despite all of the steps that appellants take, and that they basically did everything but file this one thing. I am precluded from being able to create an equitable exception. And so
I understand that, and let's assume that that's wrong, and that
Right.
in theory, the district court had the authority to create an equitable exception, but it doesn't have the authority to just do anything it wants to, right? And so the concern I have is the time limit we have is a state rule.
Right.
Right, and so oftentimes federal courts have sort of a liberal understanding of claims processing rules in the federal system. And so we might excuse a day late in the federal system, but we don't really have that authority over state rules, right? And so if the state says you must do this in these number of days, what I don't see is our authority to say, yeah, but you didn't really have to do that.
So, Your Honor, I'd argue two things. One, in terms of what you're being asked to do here is to uphold the state agency's interpretation of a state statute and how it applies it. And part of what we've argued is that their steps in applying the statute to appellants differed from how they applied it in the past. It differed from, there's no definition in the statute, with regard to what constitutes written notice.
Counsel, I mean, I think, I don't mean to cut you off because I've read that and, in lots of ways I agree. I mean, we might think this is the most ticky-tack thing we've ever seen. But are we really being asked to uphold I mean, I guess in a sense, that's one way of saying it. What we're really being asked though is, did you exhaust? And if you didn't exhaust a state procedure in the way the state says it has to be done, that's, to follow up on Judge Richardson's question, that's what we're trying to get at. I mean, the functional equivalent cases, for example, are all state courts interpreting state court rules or federal courts interpreting federal court rules. From a federal court to stick its hands in and meddle with a state court, not just court, but administrative agency, seems further removed from that.
Well, Your Honor, I would argue that at that point, you're looking at whether Chevron deference is appropriate to the agency's decision in terms of how it interpreted.
But we don't apply Chevron to state law, right? States get to interpret state law. Right? We don't get to tell states that they got their own law wrong. And that's not the way Chevron works.
Well, but in principle, Your Honor, is what I'm arguing is that when you look at how the only agency to interpret this is one of the appellees, and so the way that they interpreted it is contrary to how they had interpreted it in the past, and so there's no check on that. There's no way otherwise there's no way to be able to appeal that decision and to be able to question. And
you're not really appealing. You're bringing a case in federal court that is a case that there's jurisdiction to bring. It's not really an appeal. It's a related claim subject to the exhaustion requirements. So, and our law has three articulated exhaustion requirements. Futility, failure to provide notice. I think the application would present a severe harm on the disabled child. Seems like you're asking us to create a fourth one, and maybe you are, maybe you aren't. What's your thought on that?
No, Your Honor, we are not. So we argued futility in the district court, and part of the basis of the argument of the futility was exactly where we are right now. Is that the state board is the sole authority.
The futility would be that like if you'd done it on time, it wouldn't have worked. Not, I just missed the deadline, right? I missed the deadline is not a futility problem. It's like a failure to like do something in a timely manner. Futility means even if you'd done it, the court would have rejected it. If you'd done it correctly, the court would have rejected it. That might be futile, but it's not futile when you miss the deadline.
Well, and so, Your Honor, again, our position is that we did not miss the deadline.
Well, to me, you don't seem to raise the equitable arguments in your briefing on the appeal. Where in your briefing can we find what Judge Richardson's been trying to get out of you? What is the equitable basis? Name one.
And so, Your Honor, we did not specify like a specific equitable exception. What we pointed to was that being able, if this court will find that it is not jurisdiction, that it is not subject matter jurisdiction, and remand it to the district court, that the district court contemplated that there was an equitable
Well,
exception.
we
and that-
agree with you, it's not jurisdictional, so we're talking about exhaustion, so we would have to give the district court some kind of instruction, and it would be something like you should consider this equitable tolling reason, whether facts exist or not. To do that, you're gonna have to tell us what the reason that we should tell the district court to consider.
Right. Thank you, Your Honor. And so we would ask that you ask the district court to consider that whether equitable tolling applies, and we believe that it does. And we would also ask that you consider whether equitable estoppel applies. And part of what we raised in our briefings with the district court was that prior to the filing in the district court, there was no disagreement, right, from the parties that the family had, that everybody had noticed. And so we do believe that, and I understand it's not res judicata, like that nobody made a decision that was based on it, but I do believe that you can look at the actions of the parties and to be able to create that.
Can you walk,
exception.
oh, I'm sorry.
No, go for it.
Can you walk through, I mean, the three requirements for judicial estoppel, right? They are adopting a position that's inconsistent with a stance taken in prior litigation. That position must have been accepted by a court, and that the party here, the agency, must have intentionally misled the court, right? That is the prior court, not this court, but a prior court to gain an unfair advantage. I don't see any of that.
Yeah, and so, Your Honor, I apologize for using res judicata. So for judicial estoppel, we believe that the first element is there. The first element is that everyone agreed and took a position, okay? That the claims were timely, that the appeal could be heard. Now, Your Honor is correct, okay? The state hearing review officer did not accept that position and rejected it.
And it's also a state hearing officer, right? So it's not a court.
It is not a court. And so, it's not a court to be able to rely on it, but it did not accept that. So and also the appellees abandoned that argument at the district court. Or that position, I should say.
Is there a case that you can point to, and maybe the IRS case you mentioned does, but it doesn't sound like it, where you have a federal court instructing a state agency to apply some equitable doctrine?
So basically the federal courts are instructing remanding to the district court and finding that it's not barred. And to be able to consider at that point, the appellees want you to look and say, well, as long as you raise exhaustion, then the case is done. But that is not consistent.
Let me rephrase my question. Let's assume we're in the district court, and we're probably incompetent to do that, but we at least think we know how things work.
Two of you were district court judges.
We were competent once, maybe not anymore. But if we're in front of the district court, you're talking to us now, is there a case where a district court has looked to essentially say that a state agency should have applied certain equitable principles?
So, Your Honor, the reason that it's hard to be able to point you to a case for the IDEA is because all of the cases where exhaustion has been found not to have happened are because the parents or the school district that tried to move straight to the district court never tried to exhaust. They tried to bypass exhaustion. The ELA case they tried to bypass, the ZG case they tried to bypass in this court, and all the other cases that are cited in the briefings. That's why this case is different. And there isn't, I'm sorry to say that there isn't. There are cases where the federal courts have found, like, for example, that the agency interfered with the person being able to exhaust and therefore was able to deem that it had been satisfied. But in the IDEA context, I haven't been able to find that because the cases that make it are where people never even attempted. And so here, that is a different set of facts. These parents filed due process, 7-day hearing, filed an appeal, but they did all that they could do. And there's just the one question of the timeliness. Okay, thank you.
Thank you, counsel.
Good afternoon, and may it please the court. Steve Rawson here on behalf of the Durham Public Schools Board of Education, along with the attorney for the State Board of Education, Ms. Tiffany Lucas. Now, there are a host of analytical paths that are available to the court today, but ultimately this case comes down to two things. Exhaustion of administrative remedies under the IDEA is required, and the appellants did not exhaust. Now, I do want to go straight to, I think, the core issue that this court was interested in there in terms of equitable exceptions. Before
let me start before that, if you don't mind. You were kind of assuming there's an exhaustion requirement. Where is the exhaustion language that you say exists in the statute?
So, Your Honor, there are two areas I think of exhaustion that are relevant here. One is in 1415L, which is the specific exhaustion provision related to ancillary claims, 504 claims,
Right.
ADA claims, that speaks to whether you have exhausted the IDEA in order to access.
Doesn't it, that's talking about the ADA and the RA claims.
That's correct, Your Honor.
And it does use the word exhaustion in that provision.
It does.
Is there any provision where the word exhaustion is used in respect to a direct IDEA claim?
There is not, to my knowledge, Your Honor. The sections that are relevant are 20 U.S.C. 1415F and G, which speak to what the petitioner shall do. They shall file with the lower tier review that the state sets up, and then they shall file under G if there's a second tier. They have to pursue that. Courts for the entire 50-year history of the EHA and then the IDEA have interpreted that to be an exhaustion. You must do that.
Does it add anything to the argument that there've been 8 prior cases where the procedure that the appellate followed in this case was done and there were no problems?
So, Your Honor, at this stage, because of the standard of review that we're under, we take the pleadings as true. I cannot speak as counsel for the Durham Board whether that is accurate, what the underlying facts of each of those circumstances may be. But the allegations in the complaint are that there have been these 8. I do not believe that is relevant here for several reasons. One is that the law is what the law is, and if the appellant did not comply with the law and the state review officer applied that law strictly, that is within his power. The second piece is that this state review officer is an independent person appointed by the State Board of Education. We have different review officers through these. I do not know whether this review officer or others have been among those 8 alleged cases where this procedure has been used. But the third piece of this is that I've lost the third piece. I apologize, Your Honor.
Let me ask a question, and maybe it'll pop back into your head. We do have a decision, EL, that your colleague referred to, and while it found that the two-tiered appeal, two-tiered system didn't present a problem, it seems to create this concept that state administrative procedures, if they undermine the purposes of the statute, can be, that a federal court can, excuse compliance with them. I know they found that it was not the case there, but that kind of concept's embedded in that case. Why don't we have that here? We have, for all the reasons that were just said, no question, everyone knew the appeal was going on. No question, they got it in some fashion or another. Why isn't this undermining the purposes of the IDEA?
So, Your Honor, to answer that, I think I need to go back a little bit in terms of the original question that has been brought to this court, which is whether this is jurisdictional claims processing and what that means. depending on the scenario that the court takes. Obviously, this court has previously held that exhaustion under the IDEA is jurisdictional in MM versus school district, and most as recent as 4 years ago in ZG versus Pamlico County. I think we can all agree if this is jurisdictional still, then the case ends with the failure to exhaust. There is no equitable remedy available there, other than, although you noted, Judge Quattlebaum, earlier, that this court has laid out those 3 very narrow exceptions to exhaustion, even under a jurisdictional realm, which would not be the typical
Doesn't that
realm.
kind of tell us it's not jurisdictional?
I'm sorry, Your Honor?
Doesn't that kind of give us a good hint it's not jurisdictional?
It may, Your Honor, it may, and you won't hear me vociferously arguing for jurisdictional rule here. I think that is the precedent that this court has held. Typically, this court doesn't overturn that unless sitting on bonk, but if this panel were to proceed to a claims processing rule, I think there are 2 ways that this could go. The first is that, as some other federal circuits have done, to examine the question, is this jurisdictional versus claims processing, to, as you said, say this looks a little bit more like a claims processing rule in light of Fort Bend and its predecessor cases, but it doesn't change the outcome in this case, so we're not going to upend our jurisprudence. That was the Second Circuit, the 8th Circuit, and 10th Circuit at this point have done that.
Well, let's talk about a couple of other issues. If we say this is a claims processing rule, then we got to consider other principles such as mootness and standing. So in this case, the student is no longer, she's left the Durham Public School. And number 2, whether she has standing to sue SBE, whose involvement is relevant to events, was more attenuated in the Durham Public School. So I mean, she may have a right to sue the Durham Public School, but what about SBE?
So, Your Honor, I think,
And the mootness argument.
respectfully, I'll defer to the state on whether there's standing to the state. I personally don't think there is, but that's really an argument for Ms. Lucas, if the court will allow me to do that. As to mootness, I think that there are a couple of issues that come in here. One is, as we've noted, the issue that was at the core of half of the case was this contract, and that contract's been abandoned, and the district court was made aware of those, but did not reach that issue. But I don't think we need to reach the question of mootness or standing here yet, Your Honor, which is that even if we're under a mandatory claims processing rule, the Supreme Court has said several things there. One is, and this is in Hamer versus Neighborhood Housing, that a mandatory claims processing rule, if properly invoked, must be enforced. And here, that has been done. As soon as this case was filed, there was an exhaustion argument made at motion to
But
dismiss.
isn't that really the question, whether under Steel Co. and Senecam, whether we can do those questions before we do jurisdictional questions? I mean, Judge Floyd wants to talk about the jurisdictional questions, and just posit for a minute that we think this is not jurisdictional. Generally, we think we do jurisdiction first. Obviously, Senecam says that's not always true. Do we think that this claims processing rule is something that we could do before we address questions like standing and mootness?
No, Your Honor, I don't think so. What I was trying to communicate there is that the outcome of the claims processing rule doesn't change the outcome of the district court's analysis, and therefore the district court did not reach those issues. But yes, if we had to go back and say jurisdiction first, you could look at mootness and find that the 504 case and the ADA case, which are based at least against the Durham Public Schools on the issue of mootness of the contract, that you could find that contract has been abandoned and is no longer used. There are no exceptions involved there, and that claim would still be moot and would not be reachable. As to the state board, again, I'll allow Ms. Lucas to make her argument. The briefing there, I think, was done that standing would also be a barrier to those 504 and ADA claims. Whether there's IDEA mootness, Your Honor, is not an issue that's been briefed. I do think that there is an issue about whether this can be remedied, because they got everything they were supposed to get under the IDEA. They got
Can't they seek? I can't recall if they allege this. Maybe you can help me. But I mean, can't they seek compensatory damages based on what happened before they left the school district?
They could seek remedies under the IDEA, which may include compensatory education, or not monetary damages. Yes,
that's a bet.
Yes, Your Honor, that could potentially be available. It was obviously not found by the ALJ to be appropriate because they did not meet their burden of proof in the case, and they did not have the opportunity, because they failed to exhaust administrative remedies appropriately and appeal appropriately, to have the state review officer review that. That is something that is usually available.
Can
under
you,
the
can you
IDEA.
come back to why this hyper-technical analysis or approach to the appellate process here doesn't undermine the IDEA?
So yes, Your Honor, I think the word hyper-technical may be overstating it. That we
Fair
do
enough.
have an issue here where there are rules. The state statute is where we would start here, and this is 115C 109.9. And it states that if a party is aggrieved by the ALJ's decision, they may appeal by filing a written notice of appeal with the person designated by the state board for receiving such appeals. That's very close to a quote. Two pieces I want to highlight of that. One is filing, and second is the person designated by the state board for receiving those appeals. So one question is, did they file? And two is, who did they file it with? And what happened here, and this may be helpful as well, is to lay out the structure here. The Office of Administrative Hearings is a quasi-judicial body that is created by statute. And its only relationship to special education is that in the state of North Carolina, it is given jurisdiction to hold these hearings, these trials at the first level. This North Carolina State Board of Education is a constitutionally created body. They are not the same. They're not even related, except for this one little piece that there happens to be this niche role for OAH in the special education review process. They are not the same body. What happened here is the original hearing occurred, and then there's supposed to be a bridge to the State Board of Education, an appeal that has to be filed with the person designated to receive such appeals. That person is indisputably Teresa King at the North Carolina Department of Public Instruction. The appellant's complaint states on its face that they filed with the Office of Administrative Hearings. Now, they say the Office of Administrative Hearings sent that to Ms. King, and we take that as true at this posture, but that doesn't mean they filed with Ms. King. They filed with the Office of Administrative Hearings, which does not have a role once it has completed the record of the hearing below.
Sure. Well, I'm not really contesting there wasn't absolute requirement, compliance. So, I mean, I think that's, the district court found that, and it's probably hard to say that was wrong. But, as you know, I mean, y'all conceded below there was notice to everyone. And that, what I'm really trying to get at is assume failure to comply, because if you have comply, you don't look to this undermining the statute concept. So
yes,
so
Your Honor, and I'm
that's
sorry,
what
I keep not
trying
getting to that.
get at. I mean, we know they didn't technically comply.
Yeah, so I would argue, Your Honor, the opposite, that in fact, making a decision that undercuts what the district court did here and the state review officer did is what would undermine the IDEA's process. Because court after court after court has talked about the importance under the IDEA of this hybrid system where the state is left with the substantive educational decision-making process. And the federal courts do not get involved until the state has had a full opportunity to review as the educational experts in those cases. The IDEA is very clear on that. And so if this court were then to take that away from the state and say, well, you don't get to apply your own rules, you don't get to interpret them as the IDEA is done in North Carolina as the educational experts in the situation, the federal bench is going to come in and change that. That to me would undermine the purposes of the IDEA, not the opposite here. But also, this goes to these equitable exceptions. I do want to make sure that I address this quickly. There are no equitable exceptions available here for a couple of reasons. One is that this court has made clear that only 3 of them exist at this point. Appellant has not identified in their briefing what the equitable exception would be, and that's a problem, Your Honors, that the briefing would need to tell this court, this is the equitable exception that applies. That does not appear before the district court, with the exception of the futility piece that the district court handled at length in its opinion. It does not appear in the opening brief to this court, and it does not appear in the reply brief to this court, again, with the sole exception of futility. So what the appellant is asking in the end here is that this court simply remand to the district court with instructions to give the appellant a do-over and to argue all these equitable exceptions that were not raised and frankly have not been created.
Although to be fair, I mean, it wouldn't have made a ton of sense to make those arguments for the district court because it was a jurisdictional rule then, right? I mean, that's a little, I mean, I understand your point in the court here, they were arguing it's not jurisdictional, and then they don't flesh out very well the reasons that apply, but they really didn't have the opportunity to argue in the district court, right?
Well, Your Honor, there are those three equitable exceptions that have been articulated by this court. They only argued one of those. But even so, when they came to this court and introduced for the first time the argument of mandatory claims processing versus jurisdiction, that was the time to say, here's why it matters. Mandatory claims processing allows you to consider equitable exceptions. Here's the one that applies, or here are the three that apply. That does not exist in their briefing anywhere. This court should not invent one when the United States Supreme Court has reserved that question repeatedly, that it does not even do so. And so we would ask this court to affirm the decision below.
Thank you, counsel. Mr. Lucas, we're happy to hear from you.
Thank you, Your Honors. Good afternoon, Tiffany Lucas on behalf of the North Carolina State Board of Education from the North Carolina Department of Justice. Your Honor, I would be happy to address any State Board of Education specific questions from the start. If
You might start with Judge Floyd's question.
Yes, the question regarding the standing and whether that comes into play, and that is where I would like to start as well. As Your Honors well know, the district court dismissed the amended complaint on the basis of lack of subject matter jurisdiction for failure to exhaust administrative remedies. However, this court, of course, may affirm the dismissal by the district court on the basis of any ground supported by the record, even if that was not the basis relied upon by the district court. And here there are several other grounds upon which the district court could have dismissed the amended complaint with respect to both defendants. But I'm here specifically to address the basis upon which dismissal was appropriate as to the State Board of Education. And the primary basis beyond failure to exhaust remedies in the jurisdictional question is on the basis of standing. Because standing is a jurisdictional question, the courts must independently ensure its presence. This court.
Can you answer the question I asked your colleague as well? Why under, just from an order of decision perspective, if we found that this is a claims processing rule and not a jurisdictional one, the administrative exhaustion piece, that's no longer a jurisdictional question, but under Senechem and the Steel Code framework, can we treat that as a threshold matter like form non-convenes or other issues that can be decided at the same time as jurisdictional questions like standing? Or do we, in your view, have to look to standing before we address the claims processing rule?
I think the standing has to be addressed at the front end.
Right, no, they both have to be addressed at the front end, but the court in Senechem says there's certain threshold matters that are non-jurisdictional, but because they're a threshold, we can decide them before jurisdictional questions if we choose to do so. And that's the sort of holding of Senechem, maybe not totally consistent with Steel Code, but the question is, why would a claims processing rule, even if non-jurisdictional, not fall within those threshold issues that Senechem identifies as being issues that could be addressed before something like standing?
It may be the case. I think that is unclear, but for the purposes of this case and the question of standing, I think it is apparent that the plaintiffs did not have standing to sue the state board. The elements of standing are very clear, and there are only a few, but they are that the plaintiff suffered an injury in fact, that the injury is fairly traceable to the challenged action of the defendant, and finally that it is likely to be as addressed as opposed to merely speculative that the injury will be redressed by a favorable decision. And here it is apparent, even on the face of the complaint, that the plaintiffs have failed to satisfy the second prong of the standing test, and that is the causation prong. If you carefully review the amended complaint in this case, it is clear that the plaintiffs don't allege that the State Board of Education took actions that caused the injury to the plaintiffs
in this matter. The allegations that
Why isn't it the rule about experts?
well, the rule about experts. So I think we have to pay careful attention to the timing of the sequence of events in this case. The question about whether the contract provisions in the contracts between Durham Public Schools and the independent evaluators, that question was not brought to the state board's attention or the Department of Public Instruction's attention until those contracts were already being implemented and used in connection with the plaintiffs in this case. They weren't brought into play or into issue as part of the due process proper. It was raised as an issue in a state complaint process, which is kind of a parallel administrative decision. But even in the state complaint filings, there was no indication that these plaintiffs in the due process and now in this lawsuit were the subject of the state complaint. And the State Board of Education and the Department of Public Instruction reached their final conclusion about the propriety of the various challenge provisions in the Durham Public Schools contract well after anything having to do with these contracts and these particular plaintiffs. So it cannot be the case that the State Board of Education's decision or evaluation of those provisions in the IEE contracts had any bearing or caused any injury to the plaintiffs in this instance.
Thank you,
It
Counsel.
appears I'm out of time. Unless your honors have any further questions, I respectfully request that the court affirm the dismissal of the complaint here.
Thank you, Counsel.
Thank you.
We'll be happy to hear from you.
Thank you.
Thank you, Your Honors. I just have a couple of follow-up points to raise. So first, Judge Calderon, to your point about doesn't this frustrate the purpose of the IDA, I would say, yes, it does. And every time that Congress has spoken, when the Supreme Court decided Smith v. Robinson, that quickly Congress overruled Smith v. Robinson and opened with the intent to open the doors and to be able to allow parents to fight and to litigate on behalf of their children. And I think interpreting this in such a narrow way.
Can you respond to your colleague's argument? Like, your colleague sort of says, you know, listen, a big part of the IDEA is to like let the states address these issues as an initial matter. And we agree that states and federal courts and agencies can have rules, right? There's not just like unlimited time to do whatever you want, whenever you want. Like, you can have rules. And as a result of you filing late, the second tier didn't get a chance to, you know, apply its expertise. And so if we cut that out, then, you know, each plaintiff that shows up just says, well, I'll file late. That way I get rid of this second layer. And so I'm gonna file late, get rid of the second layer, and I'll just run off to the federal courts and they'll, you know, hand out baby Ruths, right?
So I will address that, Your Honor. So first, in North Carolina, as Your Honors are, I'm sure, are aware, the second tier review has been repealed. And so, but to the bigger point of making sure that we have the opportunity for the state to be able to resolve what the claims are, we participated in that process. I mean, we went through a 7-day due process hearing and received a result. So it, again, kind of the other cases that are looking at people who are trying to bypass that's what my colleague is kind of referring to, is because the cases, like even the cases cited by my colleague, Chavez versus New Mexico, the court analyzed and said, the parents have done enough to satisfy the exhaustion requirement. We're gonna let this move forward. Okay? And so I do feel that there are many cases where the court actually does look at the facts and say, you know, was there enough when the parents have taken action to try to resolve the issue. That is exactly the case here. And so in terms of when you asked me previously about which, you know, equitable principles, I think there's two. I think there's equitable tolling. When we persistently tried to exercise our claims, we tried to file in every way that we could. And the unforeseen circumstance was that the agency changed the rules about filing without any notice, without notice and comment, without any of the process that
Well,
would have put us on
they may
notice
have
for
changed
that.
the enforcement of the rule, but they didn't actually change the rule, right? The language stayed the same. Your point is 8 times before, they didn't enforce the rule. But that's not changing the rule. That's just saying, listen, we've been sort of lax, but we've decided we're now going to enforce the rule.
Your Honor, I am aware of no instances where they enforced the rule or interpreted the rule.
I'm aware
in
of
that way.
one. You.
Besides me. Besides,
Right? I mean,
besides the first
I got
time.
one good example.
That is a good example, Your Honor. And so, but then part of what my response to that would be is that when you also look at equitable estoppel is you're looking at whether the other party acted unfairly. And I think that is the part where.
Right, but that's like the highway patrolman sitting beside the road. People go speeding past. And then I pull out and stop, the 18th person that goes by. There's not an estoppel problem there. Like they can't stop everybody. They don't choose to stop everybody, right? Like maybe they're very generous sometimes and they're less generous others, but they still have rules.
I understand that, Your Honor, but the difference in this case is that this is the case where the state board was a party. And in all of the other cases, the state board was not a party. But in the case where the state board was a party and was a named defendant or a named respondent in the underlying due process action that was up for appeal, this is when they chose. And so I think it would be very easy to make an analogous argument to watching lots of other people go by and let them go by speeding and then target one person and say, here, we're going to apply the rule. And we're not going to let you know that this is how we interpret the rule. As we outlined in our opening brief, unlike other states that have very clear, explicit, this is what filing, this is what written notice, this is who you send it to, it has to be certified mail. What you see in that one sentence, that's all there is.
Why
There's
didn't
nothing
you
more.
argue in light of that counsel, the no notice to parents of the administrative process? There's that second exception. I guess that's really more about administrative rights than a notice provision. So it's probably not technically applicable.
Yes, Your Honor. So that would be more when we were arguing about statute of limitations,
Yeah.
which I actually think, and to answer your question about, well, what if that opens the door to people just being able to file late? Well, when you have that, we have a statute of limitations.
Does it matter that the student is no longer enrolled in the Durham public schools?
No, it does not, Your Honor. So the compensatory education to which she is entitled is backward looking. She still is a resident of Durham. She can re-enroll tomorrow.
But you asked for forward-looking relief too.
I'm sorry, Your Honor?
You asked for forward-looking relief too, such as an injunction.
The only forward-looking relief that we asked was injunctive relief as to the state board, as well as to DPS with regard to the contract. But even if this court finds that she's not entitled to injunctive relief with Durham Public Schools, she is entitled to injunctive relief for the state board. And she's also entitled to declaratory relief, because as we know, a declaratory claim can move forward when it's needed to be able to establish that damages are due. And that is the case here. So we're seeking both declaratory, injunctive, and monetary damages.
Thank you, counsel. As you probably know, we normally come down and greet counsel. It's an important part of the Fourth Circuit's tradition to show our civility and get a chance to speak to you. We have not yet reinstituted that. We certainly hope we do so soon, but we thank you very much for your argument and look forward to speaking with you some other time.
Okay, thank you very much.
We'll move straight to the next case, United States versus Leggett. Mr. Chamberlain, we're in no rush, but whenever you're ready, we'll be happy to hear from you.
Good afternoon, Your Honors. My name is Ames Chamberlain. I'm an assistant federal public defender for the Federal Public Defender's Office in the Middle District of North Carolina, and I represent the appellant Irvin Leggett today. When Officer Rochelle patted Mr. Leggett down, and subsequently interrogated him about the firearm that was found in a trash can in Reynolds Park. Under the totality of the circumstances, what started as a Terry stop transformed into a custodial interrogation for purposes of Miranda. We are asking this court to find the statements made by Mr. Leggett in the parking lot and his subsequent statements made in the detention center inadmissible as they were obtained in violation of Mr. Leggett's Fifth Amendment constitutional rights. There are two main issues before this court. The first is, was Mr. Leggett questioned under circumstances in which his freedom was curtailed to a degree associated with a formal arrest at the time he was questioned by the officer in the parking lot? And then if so, and if he was in custody when he was questioned in the parking lot, were his unworn statements involuntary based on his actions in the parking lot? And did they make those subsequent statements at the detention center involuntary, such that both statements would be inadmissible?
Can you differentiate your case from the United States versus Garner, where we found that an officer who frisked the defendant twice asked him if he had anything illegal in the car without providing Miranda warnings was permissible?
Yes, Your Honor. My recollection of that case is that Mr. Garner was asked to step out of the car. He was asked if there was I think initially he was asked whether there was anything in the car. And then once he gets to the back of the car, he was asked whether there was a firearm in the car. He hung his head down and was asked again, and he subsequently acknowledged it. This case is different for a number of different reasons. Mr. Officer Rochelle, it wasn't so much that he was asking him, he was basically accusing him of possessing the firearm that was found in the trash can. And he did it approximately 3 or 4 times. And Mr. Leggett repeatedly denied knowing about the firearm. And it was only on the last occasion, after Officer Rochelle made a statement to the effect of, "Come on, be honest with me." And he said something to the effect of, "We've been doing this too long," and indicated that this can go a long way for you in terms of your cooperating. Only then did he admit that he had possessed the firearm and went on to say that he had possessed the firearm for protection.
Is that, would your holding apply in any other circumstance? So what I'm trying to understand is sort of the scope of what you're asking us to say. And I think what you're saying in response to Judge Floyd is that anytime an officer says words to the effect of, "Be honest with me, it'll help you out if you tell me what happened," that is involuntary, because that is like a coercive questioning. I mean, that's the sort of, I do that to my children regularly, right? And I don't think it's coercive. Be honest with me, I'll try to help you out with mama if you give me some information, right? Like that doesn't seem coercive.
I think that's coercive, sounds to me.
I hope not. Do you understand the rub?
I understand, and that's not the argument that I'm making, Your Honor. Every case is different when it comes, they're very factually driven when it comes to these Fourth Amendment, Fifth Amendment issues, and every case is unique in its own facts. And I mean, it is, but we've got the case that we talked about, which is pretty similar. And so you say, yeah, but that's different because he said, "Be honest with me," right? And like that suggests that you think that that's what matters in this case. Yes, Your Honor. And first, I would acknowledge the authority of cases that indicate that when an officer is making general assurances that end up being followed through with, that have to do with cooperation or being honest, the cases have upheld those statements as not being obtained in violation of the Fifth Amendment, not being coercive. But that's one.
The courts is also. The courts say, like, you don't even the police officer doesn't even have to be honest, right? He can mislead in his questioning, and that's not coercive.
That's true, but that's one fact in this analysis, and it's under the totality of the circumstances.
Well, let's so let me kind of maybe step back and ask a question. Do you contend that the district court misstated the applicable law, either for the scope of a Terry detention or for the requirements of custody?
No.
So we're not talking about a legal error. We're talking about the application of the facts here to the law that the district court cited, right? And pretty much everyone agrees on.
Yes, Your Honor, but I would tell this is a unique situation in that I wasn't counsel at the motion to suppress hearing or the attorney that wrote the brief. But in this case, I would ask the court, and the court's correct, but much of the analysis at the hearing was there would seem to be an agreement between the parties that the detention began at the time that Mr. Leggett was frisked or patted down by the officer. And I am asking the court to look back farther. And this goes both to whether he was in custody and both to whether the statement was voluntary coerced. And so when Officer Rochelle encounters Miss Marshall and Mr. Leggett over by the picnic tables, it's dark. It's a uniform officer. He has a firearm. He says the park closed at 10:30. It's not in dispute. It was midnight. And at that point in time, he has Miss Marshall and Mr. Leggett.
So he has, I just want to make sure I want you to go through the timeline, but at that point, he's got reasonable suspicion that they are trespassing.
He's got more than reasonable
Right.
suspicion.
I mean, I know that all that's really needed, right, is reasonable suspicion. But he's got reasonable suspicion that he's found a man and a woman in a park at midnight, and he's got at least reasonable suspicion that they are trespassing. And so he's entitled to investigate that.
Absolutely.
Right. And he can choose to arrest them for that, write a citation for that, or just tell them, hey, get out the park. Right? He's not required to do any of those three actions at that point in time.
That's correct, Your Honor.
And in part, like we might expect that he's going to investigate and find out why they're in the park, and that might inform his decision as to what he's going to do.
That's correct.
Okay. All right. So now tell me why he's in custody at that point, as soon as he starts investigating why they're in the park at midnight.
Well, and so the standard or the analysis is from a reasonable person in the suspect's position, so in Mr. Leggett's position. So from the very outset, he's basically been told he is trespassing. He has committed an offense for which he can be arrested, and ultimately that's one of the offenses for which he is arrested. And that's one more factor that didn't get a lot of attention at the hearing itself, but this court can consider.
Right. That's exactly the point. He could be arrested, right? But we might well just think like the reason he got arrested was not really because he was trespassing, it's because he's also got a gun and he's a felon, right? And so, okay, well, that sort of weighs heavily in using my discretion to arrest him rather than, give him his gun back and send him on his way, right? That's exactly what we want an officer to do, is to investigate. I found somebody trespassing. Let's investigate, learn a little bit more about whether this is a case that should be charged or should not be charged.
And I'm not faulting the officer or saying that he did anything inappropriate, but against one more factor from the defendant's perspective that puts him in a position, not just that he's not free to leave under like a Terry search, but it's one more factor that weighs in favor of him being in custody.
Let's assume you're right there, but that's kind of why I asked the question. Do you contend there's a error of law? And I think you said there's not. And let's talk about the custody. I mean, you talked about factors, and the district court laid out 4 or 5 factors that arguably would cut in favor of a custody determination. But then it listed 5 or 6 or 7 that cut the other way. And you got a pretty tough standard of review for us. I mean, those facts are in the record. The district court looked at the things you're talking about, said, yeah, this, but that. And under a clear error standard where we're supposed to construe the evidence in the light most favorable to the government, how do we do that when there's a litany of facts that support that determination that are part of the factors that the courts have said are appropriate to consider?
Well, this court should consider that the questioning of Mr. Leggett, while it was questioning, it was accusatory in nature.
Okay.
Each question, which is different from the Garner case, when they're asking, is there anything in the car? Or do you have anything? Every single one of those questions from Officer Rochelle to Mr. Leggett was, come on.
I think that question in the Garner case is not accusatory, right? When you're like, do you have anything in the car? And the guy hangs his head down and it's like, do you have anything in the car? I mean, those are accusatory. I mean, in some sense, they're just as accusatory as, be honest with me, like, is the gun that we just found yours? They seem equally accusatory in my mind.
I would contend that the Mr. Leggett's situation is distinguishable from Mr. Garner's situation. And it goes on for approximately 2 minutes from the time that Sergeant Mulgrew finds the firearm. So I think everyone would agree that a Terry stop had already taken place. And
Do you agree when they find the gun in the trash can by where they had been in the park, that they had reasonable suspicion at that point that he had a firearm?
What's troubling is that Mr. Leggett was the target of the investigation regarding the firearm from the very beginning. There's 2 people there. There's Miss Marshall and Mr. Leggett. The investigation solely targeted Mr. Leggett. I don't know why that is. I don't know what was in the officer's mind, but when Sergeant Mulgrew finds the firearm, he
Right,
says,
but I understand, maybe he had reasonable suspicion of 2 people that had the gun, but they had reasonable suspicion that he was involved with a firearm. And given that it is hidden, they would have reasonable suspicion that he is unlawfully in possession of the firearm. I'm just asking, do you agree at that moment in time, when the pat down occurs, that they had reasonable suspicion that he was involved illicitly in some manner with a firearm?
yes, we're not challenging the pat down. And I don't know.
And then, so then maybe I'm having a little trouble, right? So they've got reasonable suspicion. At that point, he can do a Terry stop, he can do the pat down, and as part of a Terry stop, as in Garner, you can do at least some investigation of the crime, just like he could do with the trespass. You can ask, why were you here? What were you doing? What's going on? Because I'm entitled to investigate a little bit along with patting you down. Right? So why is it that what we have? I mean, I don't mean to just ask the same question again, but.
No, and I'll try to do a better job answering the question. There's 2 investigations that are emerging. There's no question that Mr. Leggett has been told that he is committed a 2nd-degree trespassing, which is an offense for which he can be arrested. So
An
at
offense
that
for which
point,
he can also not be arrested or not charged. I mean, all 3 of those that we just established, those are all 3 options.
that's true. That's true. But we would argue that in Mr. Leggett's position, that goes to whether a reasonable person in Mr. Leggett's position would believe that he was actually in custody. And that's why all these factors matter. And it also matters, court may wonder why I'm pointing out the fact that he was the sole target of the investigation, is this is being communicated over radio.
Counsel, I'm just thinking about that. I mean, so that means a person who's, going, too fast down the highway and is pulled over for obvious speeding, and then an officer sees a gun in plain sight and then asks a couple questions about the gun. It's like you're suggesting, I guess, that the person who commits the first crime or engages in activity that is reasonably suspicious of a crime somehow comes out on the better end of the inquiry here.
No, I think what's different about that, if someone's pulled over for a traffic violation, it may not amount to an arrestable offense.
But it might. You can get arrested for some, right? I mean, that's what we don't know, right?
And that would certainly factor in. I mean, if the person's going 110 in a 45 zone, that person is well aware that they could be arrested and may believe at that point that not just that they're not free to leave, but that their freedom's curtailed to a point that it's tantamount to a formal arrest.
So it sounds like the 2 things that you're hanging your hat on maybe as distinguishing factors is that there was the trespass, conduct created an increased appreciation of custody or objective feeling of custody. And then the accusatory nature of the questions. Are those the 2 distinguishing factors that this makes this case different from your perspective?
It's more than that, Your Honor. It's late at night. While it is a public park, there's no one else there besides.
Right, but he's got to be comfortable late at night in a park. He's the one that went there, right? I mean, there's no reason we would think of that he's uncomfortable. I mean, a reasonable person who goes to a park in the middle of the night can't be like particularly concerned about it, right?
when you encounter a police officer and you're in the park after hours and it's dark and you're in the presence of two armed officers and there's two patrol vehicles who are parked in close proximity to the white Subaru, parked diagonally, and their Officer Rochelle acknowledged during cross-examination that he, at times, will rest his hand on his firearm when he's questioning a suspect, and it's possible that he could have done on this occasion. All those things weigh in favor of someone being in custody and creating a coercive environment.
Did you listen to the tone on the tapes of
I
the
did.
quick? It didn't sound, it sounded pretty pleasant.
Well, we acknowledge that I think it was referred to as moderate. I think both sides referred to the tone or general demeanor of the officer as moderate, but the words he was using was, "Come on, man, tell me how that firearm got there." It wasn't, "Is there anything back there? Do you know anything about there?" It wasn't that type of investigation. It was, "Come on, that officer didn't plant that firearm there. You know what it's doing there. We've been here long enough." All these things factored in and changes the dynamics when then the officer says it's going to go a long way to helping you if you'll be honest with me. And while 2 minutes doesn't sound like a long time, when he's repeatedly accused in that context, out at night, it's dark, the officer testified even with the headlights of the patrol vehicles not being illuminated, it was dark. I see that my time is up. I'm happy to answer any questions.
Thank you, counsel.
Thank you.
Mr. Reese, we're happy to hear from you.
Good afternoon, and may it please the court. Morgan Reese on behalf of the government from the Middle District of North Carolina. Your Honors, the question before the court this afternoon is whether the district court erred in denying the motion to suppress Leggett's unwarranted statements as a result of a valid Terry stop. And the answer to that question, considering the evidence in the light most favorable to the prevailing party, is no. These questions and answers were given as part of a valid Terry stop. And further, in the voluntary custody analysis, the statements were voluntary. On April 24th of 2019, Officer Rochelle was on duty with the Winston-Salem Police Department. He drove past a park sometime between midnight and 1 a.m. The park was closed. He saw a car parked there, so he went to investigate. Upon approaching, the car was empty, so he walked further into the park. And that's where he encountered two people, Leggett and Marshall. The three of them—
Counsel, can I stop you and ask a question that is maybe getting to the end? So I'm sorry to get you out of order, but in the district court's order, he concludes the kind of Fourth Amendment portion before going into the Fifth Amendment portion with this. He says these facts and recounts probably a lot of what you were going to say, present a concern for officer safety, including the need to determine why the firearm was present and whether anyone else was in the park who was armed, and then said limited questions to this are within the confines of Terry. And my question is, did any officer testify that those were the reasons they were conducting the investigative questions to Mr. Leggett that they did?
Certainly, Your Honor. So the officers who both testified, they are focusing specifically on Officer Rochelle because he was the one who conducted the questioning of Leggett. He told the court at the district court suppression hearing that it was unusual to find firearms in trash cans at night. Right. And so as part of the district court hearing, I do believe that he also informed the court as part of his testimony that certainly they're trying to figure out who owned the firearm and what the whole situation was. And it's highly unusual for officers to find a firearm in a trash can at night.
I hear you. And that conclusion makes some sense to me too. I'm just trying to see if anyone said it from an evidentiary standpoint. The lawyer argued it, maybe, I don't know if that's you or someone else, but the lawyer argued it after the testimony went in, I'm just trying to figure out as to whether there was actually evidence that one of the concerns was either officer safety or there was someone else in the park.
Your Honor, so for Officer Rochelle's testimony, he goes through what happened, obviously, and provides that factual basis. I don't recall specifically what he said about what his motivation was at that point in time.
Does that matter? If the district court, says that a appropriate reason is reason A, and in theory, that's a good reason, a legitimate reason, but the testimony is, I did it for reason B. Does that create a problem for us?
Your Honor, I don't think that it does. And I'll tell the court why. That's the instance for this court is, in the analysis, is whether the officer diligently pursued a means of investigation to confirm or dispel his suspicions. So in his cross-examination, he does admit that he believed the firearm was Leggett's. And so his questioning was obviously to confirm or dispel that suspicion. And so I think that in this analysis, the court has to have answered that inquiry. It's not a bright line rule.
Is that inquiry, so Judge Quattlebaum's question suggested the inquiry is a subjective one, right? Where we tend to think about, cases like Wren and otherwise, that we analyze these questions not based on the subjective belief or rationale of the officer. That might be evidence, but there's an objective inquiry. We talked a little bit about the objectivity on the Mr. Leggett's side, but in the inquiry also fundamentally an objective inquiry, and not specifically what he happened to be motivated by at the moment?
It certainly is, Your Honor. And based upon that objective inquiry, this court has the ability to look at the totality of the circumstances. So certainly whether or not the officer directly testified that I was inquiring about reason A, but the district court reasoned about reason B, to your point, Your Honor, it is an objective inquiry.
So your position would be that that conclusion by the district court is not a statement that the officer subjectively believed that officer safety was the rationale, but instead it was objectively reasonable to have that belief. And we don't have to ask the question of whether that was what was between his ears at that particular moment.
That's absolutely correct, Your Honor. Your Honor, so under this analysis with Terry, we have this two-prong approach, but this first element of whether or not the officer's actions were justified at the exception really isn't an issue here. Everyone agrees this was a lawful Terry stop based upon the firearm. So then it does turn to the second inquiry of whether the officer's subsequent actions were reasonably tailored to the circumstances that justified the stop. So we have to make an inquiry about scope and duration. And then that refers back to the no bright line rule that I mentioned earlier in looking at the totality of the circumstances.
I don't know if this goes, I think it would go into scope, I guess. Does the nature of the questions, there's been discussion over they were accusatory or more accusatory than other cases. Forget what side of the line that falls on, but does whether the tone or the coercive nature of the questions matter, and if you're in as to whether it's still within Terry?
So certainly, Your Honor, off the bat, Terry is obviously a seizure. We're not contesting that, but Terry is a unique circumstance because, as the Supreme Court has held, it does not exert upon a detained person pressures that sufficiently impair his privilege against self-incrimination so as to require that he be warned of his constitutional rights. So in answering your question, I think that's an important framework, and that was from Berkmer versus
But that depends on whether your questions are Terry type questions, right? Or is there a way that you can be asking questions, which the law says officers can do, in relation to a stop? Is there a way you can do those in a way that moves you into a situation where you need those warnings, even if the subject matter might be within the scope of a Terry search?
Well, first of all, Your Honor, I think the analysis of an investigation, this court holding that coercive nature of questioning during Terry, I think Terry in and of itself, officers have it in, they're in the moment. They're in the heat of the action. They're trying to decide. They have concerns about officer safety. They have concerns that they have reasonable belief that criminal activity is afoot. So questions in of themselves could be coercive in nature. The government does not contend that they were coercive in nature in this instance, but I don't think that that would necessarily tilt the favor in finding that a Terry stop had been unlawfully extended, just given the nature of Terry stops themselves. I mean, if you look at the initial Terry case where the officers are watching individuals case to rob a store, the officer has to act on their feet and make a quick judgment call. The question then becomes, did that extend impermissibly?
Do you know the timing of, was the gun found first before the frisk or after?
Your Honor, the gun was found first. So both in the district court testimony, the court can review that, but also in the supplemental joint appendix, video number 4, the court can watch that.
Does that make a difference?
Your Honor, it certainly does, because the firearm was found in the trash can. The officer, Sergeant Mulgrew, then radios to Officer Rochelle. That transforms the nature of this interaction.
Do you agree that before, you don't have to agree, but, well, maybe, do you agree that before they found the gun, that they would have lacked reasonable suspicion to do a Terry pat down? They had reasonable suspicion of a trespass, but it's a little hard to say that there was reasonable suspicion that he would be armed and dangerous until they found the gun.
I think that's an appropriate analysis, Your Honor. Certainly the firearm changes the whole analysis, but I think the district court also made an important note in its findings and conclusions here about what impact that prior interaction has on everything that happened after the Terry frisk, which was that Leggett and Marshall were going to have to return to their parked car anyway when Officer Rochelle encountered them in the park. So they all were walking back to an area where they were going to have to return. So any sort of environmental condition that would have possibly impacted or otherwise said it's coercive or custody, they were going to be there anyway.
Well,
they
they're
had to
gonna
walk
be
back to
there,
their
but
car.
they were going to not be there with 2 police cars and 2 police. I think there's facts both ways on that. But it's not like they're in the same situation they were expecting to be in.
Certainly they had other guests with them at that point in time, Your Honor, when they were returning to the parking lot. But Officer Rochelle didn't have his firearm drawn. He did have a flashlight out because it was dark. And then he walks back to the parking lot with the 2 of them. He even leaves them at a point in time because he has to go back to his car to get something from his car before he goes back to talk to them again.
One of the things your colleague suggested is that it matters here that the trespass offense was an arrestable one. And so a reasonable person who is under investigation for trespass would then assume, I believe, or know that since it was an arrestable offense, they were likely to be arrested or they were arrested. Can you talk a little bit, do you agree that the nature of the offense matters? And the question is how and at what point? I mean, maybe if there was a murder, I mean, you could imagine a little bit of a difference here, but how does that play into the calculus as to whether someone's in custody?
Your Honor, to first answer that question, I do want to point out that both parties here agree that the Terry stop was valid once the firearm was found. And so I do think that's an important distinguishing factor because the analysis then basically changes because everything that happened prior to that doesn't really impact the Terry stop. The Terry stop
it impacts the state of mind potentially, or the objective state of mind of the defendant.
That's absolutely true, Your Honor. And I
think that's the point he's making, that there's this factor, he's got a greater risk, I may be arrested, and in the custody analysis, that matters.
Certainly, I understand the court's point with that. However,
well, I'm not making a point, we're asking your response.
I think I am.
Yeah.
Yes, Your Honor. And I do see that. However, if you want to turn to a custody analysis, a true custody analysis under whether or not the suspect's freedom was curtailed to such a degree associated with formal arrest, let's look at the factors. We consider things like time, place, purpose of the encounter, the words used by the officer, the tone and general demeanor, the presence and number of officers, potential displays of weapons, physical contact, isolation, or physical restrictions. So taking each one of these individually, Leggett was never placed in handcuffs. It was a reasonably relaxed conversation given the circumstances. There were no weapons drawn. They certainly had weapons on their holsters, but they were not drawn. One officer was asking the questions in the circumstance to both Leggett and Marshall, who was standing right there. There were no threats made, and the police
What do you
cars.
do with your colleague's concern that the police were selectively targeting Mr. Leggett and ignoring Miss Marshall with respect to the gun? Maybe there was some trespassing for both of them, but once they found the gun, they sort of said, we're going to talk to the guy and we're not talking to the lady.
That is what happened, Your Honor. There is no
I
discounting
got that. But what
that.
do you do with that fact?
If the court looks specifically at the interaction between the three individuals as they're standing in the parking lot, it's a little bit more nuanced than what we've been talking about, which is just these direct, categorized as accusatory questions. The interaction, if the court looks at video number 4, starting at about 3 minutes and 12 seconds, that's when the frisk concludes. The officer turns to Leggett and says, "What's the gun over there for? Be honest with me." Leggett then admits to him, "We were over there, but I didn't have no gun." Rochelle then says, "Where's that?" Leggett responds, and there's some back and forth at that point in time. Then 15 seconds later, Rochelle asks, "You were down there by the benches," to which Leggett responds, "Yeah, I don't know where he got it from though. We were down there by the benches." Miss Marshall then interjects herself at that point in time, and she starts talking about why they're out in the park and the circumstances. Leggett then starts talking again, and some of the audio is muffled, so this is just clips of what was happening. But then he volunteers, "I just did 15 years. So what we have at this
I
point
got
in
it at
time-
that point. As soon as he says that, I get the focus that goes to him. But at least my recollection, she doesn't get the frisk that he gets, right?
No, correct.
I mean, the tenor of the conversation, I get she interjects at some point, but the tenor of the conversation and watching the video and the muffled pieces that we can get out of it is that the focus of the investigation is on Mr. Leggett. And my question, assume that sort of like, it is factually true, but you can also assume it. Does that matter to the analysis?
No.
Help me know why.
It doesn't matter to the analysis, because when you consider the totality of the circumstances here, the officers can only ask questions of one person at one time. They certainly can then turn to her after they're done with asking questions.
But the frisk looks a little different, right? Like if he thought both were a risk, he would have frisked them both and then asked questions.
He didn't do that, Your Honor, but I don't think that the lack of action or lack of asking questions invalidates what he did do.
It may not, and let me ask you if something else matters. I don't think, one of the things he was arrested for was trespass. Is that correct?
Your Honor, I don't have that information in
Okay.
front of me. I know that the officer said that that's what he was
That's what
intending
he
to
said
do.
in the
Correct.
testimony, and I don't think he was trespassing any more than she was. So does the fact that he thought about arresting him for trespass and not Ms. Marshall matter?
No, Your Honor, it doesn't matter, because again, what the officer did not do does not invalidate what he did do. And so we look at what he did do, and that's the question, is that appropriate under the law? And the answer is yes, considering the scope of the Terry stop, and then considering the scope of the questions, which both in context and duration lasted 90 seconds from the time of the frisk to the time of admission. If you want to go further, you could say 2.5 minutes from the time of admission, from the time of the frisk to the time of the arrest. Putting this in context, that is not an unreasonable extension of a Terry stop. If the scope of this Terry stop was to investigate a firearm that was found in a trash can after dark in a closed park and there were only 2 people nearby, then that scope of questioning was completely valid and legitimate and limited to that inquiry. Because of that, this Terry stop was not only valid at its inception, but throughout the questioning continued to be valid. Your Honor, the defense would argue that because nothing of evidentiary value was found as part of the frisk, then it should have stopped. However, as the court has pointed out, that's simply not what the standard is in this circuit. The Gardner case is very clear on that point, where they conduct a traffic stop, they do a frisk of the defendant, and they find nothing. They were able then to ask a couple more questions, and at the conclusion of that, they get an admission and find a firearm. Further, the defense would have us establish a rule where officers would have to end questioning if the defendant either answers in the negative or is otherwise unresponsive to questioning. And that's simply not, again, just not the standard. The standard is whether or not the officers were diligent in their pursuit of their investigation and whether it was narrowly tailored to the scope of the stop, which it was here. Your Honor, if the court has no further questions.
Oh, I want to make sure I heard you right. I thought you said the gun was found before he did the frisk.
Yes, Your Honor, that's correct. The gun was found, and then the officer, Sergeant Mulgrew, radioed to Officer Rochelle and
So-
said, pat him down.
So what does that argument about having done the frisk and don't find anything on him, what does that have to do with anything?
Your Honor, from the time of the frisk, the time of the admission is really a point about the duration of the stop. If the court watches the entire body camera footage from Officer Rochelle at the scene, from the time that it starts, which is not necessarily the time that Officer Rochelle got on the scene, it was just the time that it was activated, it's just under 5 minutes long from that entire time. So even looking at the maximum time that Officer Rochelle was out on scene, 5 minutes is simply not too long for an officer to conduct an investigation part of the way through firearms found in the dark in a closed park. So if there are no further questions from the court, I will conclude and just say we ask the court uphold the findings of the district court and denying this motion to suppress. Thank you.
Thank you, counsel. Mr. Chamberlain, you got a few minutes if you'd like.
Thank you, Your Honor. Your Honor, I would just reiterate that it's our position that the Terry stop began from the moment Officer Rochelle came into contact with Mr. Leggett and Ms. Marshall. So from the moment he interacts with them out at the picnic table. So it didn't happen when he pats him down. To clarify about when the firearm was located, after Ms. Marshall and Mr. Leggett walked back with Officer Rochelle from that area where the picnic tables were, Sergeant Mulgrew, who had arrived, walked down in that direction, searches the trash can, finds the firearm, and then he radios to Officer Rochelle, pat him down. He didn't know his name, but that was Mr. Leggett. So we would contend again that Terry stop began earlier. While it's absolutely true that in a Terry stop situation, the officer is allowed to ask questions to either dispel or confirm any suspicions. After that search took place, and there's no firearm that's found, the difference here is, again, that's why I was pointing out that there's already been an offense for which Mr. Leggett is aware that he can be charged with second-degree trespass. And he's the sole target of the investigation, which is basically singularly focused on finding the owner of the firearm. And every single one of those accusations, not questions, was directed at Mr. Leggett. And I would ask the court, there's no harm to the government in that situation where a reasonable person in the suspect situation would believe that their freedom of movement has been curtailed to a point where it's tantamount to a custodial, a formal arrest. What is the harm in requiring that the officer advise the defendant, who has a right not under the Fifth Amendment, not to be a witness against himself, of their rights? And the concern is that, well, he's not going to do that because the person may not be willing to talk. And that would not have presented any hardship to law enforcement in this situation.
So, counsel, let's just for the sake of discussion, say we accept some of your arguments. You know, he of course later is given his Miranda, advised of his Miranda rights. He's advised if he wants to continue talking, and he does. And, you know, the inquiry there is whether both statements are voluntary, but it's a heightened voluntary standard. I mean, it's just
yes,
the way you and I might normally think about voluntary. I think our case says, you know, a defendant has been overborne or his capacity for self-determination impaired, and, you know, and it's clearly more than just custody. How do you get past that.
But in Your Honor, as I said earlier, I don't have a case candidly that's analogous to our facts where this court has found that the initial statement where there was coercion based on a general assurance when that assurance was followed through. I think all the cases where the officer made a promise where they found out coercion was involved was when the officer didn't follow through with that promise.
Yeah, and sometimes when that happens, they still don't find it wasn't voluntary.
That's correct. So I would contend again, each case, the facts are unique. And the situation of the not questions, repeated accusations that were geared solely towards Mr. Leggett. And then the court is to look at if there was coercion, if the initial unwarned statement wasn't voluntary, then was the taint from that involuntary statement, had it dissipated at the time of the second interview when he's Mirandized. And the court says to look to circumstances such as the passage of time, change of location, whether it's different officers involved in the questioning. In this case, it's the same officer. In fact, the officer actually, he caught himself, but he continued to question briefly Mr. Leggett after he'd been placed in handcuffs. He asked him what kind of gun it was, and then he sort of caught himself and said, never mind. But it was the same officer that had done the initial interrogation who did the later interrogation down at the detention center. It's unclear from the record of the exact passage of time between the initial unborn statement and the Mirandized statement. I would contend it was a relatively short period of time. And he's now in a different location where he's clearly in at the detention center being interviewed, which is inherently intimidating environment. And so we'd ask the court to find that both statements, that Mr. Leggett was in custody, that the first statement that was unwarned was involuntary, and the circumstances surrounding that, its second statement, involuntary in violation of his Fifth Amendment, and ask this court find that the court committed error and that the evidence, both statements, should have been suppressed. Thank you.
Thank you, counsel. As you've now heard twice, we like to come down and greet you and say hello. It's an important part of our tradition. We hope you get back to it soon, but we thank you both for your arguments and appreciate you coming down to Charleston to be with us on a special occasion.
Thank you so much.
Clerk will adjourn court for the day.
This honorable court stands adjourned, sign the die, by the state of the United States and this honorable court.
So now that court's closed, we are super excited to have Charleston law students here.